Hello, and welcome to today's episode of Gavels and Gowns, a Williams Mullen education law podcast where we explore topics that are important to leaders of institutions of primary, secondary, and higher education. I'm your host, Stephanie Karn, and I'm a partner in our labor, employment, and immigration section based in our Richmond office. My practice focuses on employment matters, issues involving institutions of higher education. Yes, there's an overlap between those two often, but also especially dealing with Title IX in terms of schools, colleges, and universities, and then, of course, general litigation matters. In my 31 years as a lawyer, I have both seen everything and continue to be surprised by the new issues that arise each day. One of my favorite things to do is provide training and guidance, which is just one of the reasons why I am here today. Thank you so much for tuning in to today's session, focusing on educational institutions of all levels obligations towards pregnant or parenting students. In my experience, administrators are surprised to learn they cannot be as protective as they instinctively want to be when they learn a student is pregnant or experiencing pregnancy-related complications. Additionally, with the return to the 2020 Title IX regulations, it may also be surprising to learn that Title IX still prohibits discrimination based on pregnancy, nursing, or parental status. So, today, we are going to review the key mandates under Title IX for any school, regardless of its level, when it learns of a student who is pregnant, nursing, or is a parent. Please note that while there may be other applicable national, state, or local laws, we will not be discussing those today. Of course, if there's enough interest, I am more than happy to record a part 2 and delve into those topics. But turning to today's topic, I think it is important to remind everyone what the limited but potent language of Title IX says from the outset. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So, as a baseline, the prohibition on the basis of sex includes pregnancy and parental status in educational programs and activities. And Title IX applies to all public and private schools, school districts, colleges, and universities receiving any federal funds. So, as a practical matter, and this is why we're here today, what does this mean for an institution? 1, such a student has the right to stay in school. And I'm going to use school here just for everyone as a shorthand at this point because it really is K through 12 plus higher education. And rather than keep repeating each of those separate entities, I'm using school globally. So a school cannot require, compel, or force a pregnant or parenting student to switch to an alternative program or school. If the student voluntarily opts to switch, and there are some who may choose to do so, you may have a parallel track, and that's great if you do and the student wants to. Even then, the alternate program or school must be comparable to the current or standard program or school, and it must offer similar classes and school activities. And yes, I know a few of you are like, wait a second, I offer these clinical programs, I offer these highly specialized medical programs. Yes, there are a few very fact-specific exceptions to the statement I just made about having the complete right to stay in school and you cannot force them to switch to an alternative program or school. For example, you may have a pregnant student who is currently in a clinical placement that prohibits participation by pregnant students. It's a radiology, they're studying to be an X-ray tech. There are certain chemicals within the lab that are being used. In that instance, the student may not be able to continue that class. That doesn't mean that you're automatically forcing them out of the program or the school, unless, of course, it's at a point where, they need to continue on. Your student may need to take medical leave, and then the school's obligations switch to ensuring the student is able to return to the same academic or extracurricular status as before the leave started. Very specific exceptions. That's the type of thing where I highly recommend you seek guidance from your in-house counsel or external counsel just to ensure you're doing the right thing for a student in a program. But coming back to our sort of best practices, top lists of do's and don'ts. Number 2, a pregnant or parenting student must be allowed to continue participating in all classes or extracurricular activities, including sports, clubs, after-school programs, etc. And no, you cannot require a pregnant student to submit a doctor's note allowing participation unless you require a doctor's note from all students who, regardless of what the type of physical condition or emotional condition is, requiring medical treatment. In other words, if someone who's coming outside of a concussion needs a medical doctor's note to participate in the activity, you're requiring it of anybody with a illness, an injury, under medical treatment, then yes, you can require the same note from a pregnant student. But if you don't, and it's, hey, you are a varsity athlete on our team, you're fine, there's no other medical condition, you cannot require them to have a doctor's note to continue. What does that mean in practicality? Your school offers field hockey, your school offers lacrosse, and your coach, your athletic trainer, somebody on the sidelines suspects that one of your players is pregnant. They may not have come forward. No, you cannot bench them simply because you think they are pregnant. You cannot ask them to provide a doctor's note asking if they are okay to continue playing. They are allowed to participate in that sport without any interference from you simply because of their status of being pregnant. Now, if, for example, at 9-month mark, they can no longer see the ground to be able to see where the field hockey ball is, and therefore they are not proving to be an asset as a forward where they usually play on the team, then yes, you may be able to bench them because they're not able to advance what you need in the sport. You still can't bench them simply because they're pregnant. All right, our third point on the list. A school, and this includes our individual teachers and professors, must excuse absences due to pregnancy or childbirth consistent with the documentation from any healthcare provider that's submitted. In other words, if their doctor says 3 weeks leave, for example, post-childbirth is necessary, those 3 weeks must be marked as excused. And the student who has an excused absence or absences be permitted to make up exams that were due during the excused leave. So no teacher, no professor can refuse to accept work submitted after a deadline in these circumstances, regardless of what their practice is in the class, regardless of what their syllabus says. And if part of a class grade is based on participation, then a student returning from any excused absence, again, this is always within the framework of pregnant, nursing, parenting, should be allowed to make up any participation or attendance credits. So, if the policy or practice of an individual teacher violates Title IX, then the school is in violation of Title IX. And I say that because I know, and you're all thinking as you're listening to this right now, that one teacher, that one professor, the one member of the faculty who is steadfast in, I give no exceptions, I give no breaks. If it's not turned in by 11:59 on the day it's due, it's late and I don't accept it, and I will not change it for any reason. They are going to have to change it for the pregnant student, the nursing student, or the parent if they qualify under Title IX and the regulations, or else we're going to be in violation of Title IX. Next point for us all to consider. The school must ensure that all such students are free from harassment based on sex, which can include any inappropriate or even sexual comments or jokes about pregnancy or the student's sexual activity. Caveat. If the comments are sufficiently serious as to interfere with the student's ability to benefit from or participate in your educational programs or activities, right? Coming back to our definition of harassment, just the fact that someone, makes a comment about, you look like you swallowed a basketball, which was a comment that was made to me, not as a student when I was pregnant, but already working as a lawyer, but I certainly looked that way towards the end of my pregnancy. Well, one stray remark or comment, even if the person hearing it is completely offended by it, is not sufficiently serious as to interfere with their ability to participate in our educational programs or activities. But we all know that that is a type of scale where it can be so severe and does not need to be as pervasive. It can be less severe and therefore more pervasive, but it can rise to the level of interference with their ability to participate in our educational programs or activities. So this is a good refresher point, and my fifth point here. You need a policy against sex discrimination. You also need grievance procedures that address complaints of sex discrimination. Hopefully, you already have a robust Title IX policy and grievance process. It's 2026. I sincerely hope if your school is receiving any federal funds whatsoever, doesn't really matter what part of the school is receiving them, then you are supposed to have under Title IX that detailed policy against discrimination and harassment on the basis of sex, and a grievance process that takes us through the investigation piece, the hearing piece, and the like. If you do not have such a policy or grievance process, we need to talk. Please give me a call. Otherwise, you've got it. That's great. You are well on your way. In that instance, I recommend reviewing your policy to see if it expressly extends prohibited discrimination to include pregnant and parenting students. In other words, they're already included whether your policy says it or not. So you don't have to run around and amend your policy to add a line that extends the definition of sex discrimination to pregnant nursing and parenting students. Don't feel like you have to, especially if you're at a school where getting any change to your policy requires 8 board meetings, board of trustee approval, faculty comment, and the like. But if it's something that's a relatively easy change for you to do, you've reserved the right to make minor edits to the policy, then I encourage you to consider adding that language as well, to just add in, yes, this extends to pregnant nursing and parenting students. All right, 6th point in this list of do's and don'ts and what obligations we should be considering as an institution. When requested, a school must make reasonable adjustments or modifications to assist the student in fully utilizing your educational programs or activities. Examples of reasonable modifications include everything from allowing them to take a break during class, whether it's in class, maybe to, eat saltines, drink ginger ale, be allowed to leave the class without asking for a hall pass or putting their hand up or notifying the professor to use the restroom. Absences that are excused for medical appointments when needed. Granting them access to online or homebound education, maybe depending on how the pregnancy is progressing or how late in the pregnancy that they are. Changes in class schedules or course sequencing. Extensions on assignments. It could be something as simple as they need a larger desk. They need a different chair. Maybe they need something more ergonomic. They might need a temporary parking space towards the very end. Or something more serious. They need a note taker, or they need to be able to record class based on maybe some of the complications that they are experiencing under pregnancy. Let's talk more about what we mean, though, with modifications or adjustments. The shorthand guide for what is a reasonable modification. If you provide a special service to or for a student with a temporary medical condition, such special service must also be provided to a pregnant student. What does this look like in reality? Athletes on your campus, torn ACL, sprained ankle. Do we allow them to use the elevators that are only allowed for faculty and staff? Do we have our facilities personnel, buildings and grounds, just athletic trainers, give them a ride across campus on golf carts? Well, if you do any of those, you need to also offer and be able to do that for your pregnant student. So think about what you normally provide for a student with a temporary medical condition. And yes, we would provide that as well for a pregnant student. What is not reasonable, because I think it is also extremely important to note that not every request you receive is going to be reasonable. Any requested modification that would fundamentally alter the nature of the education program or activity, by definition, is not reasonable and is something that we can turn around and say no to. Actually, listening today on the radio on my way into the office, people were talking about court reporters and could they be replaced by AI, and talking about going to court reporting school. Well, that required them to become certified to do the steno type roles and the typing themselves. So a pregnant student in a court reporter program who is dealing with carpal tunnel and cannot type while pregnant, you would not be required to provide a replacement typist. That would fundamentally alter the obligations of that course. The student themselves needs to show that they can present the skills that are required to pass the class. That is just one example of what is not a reasonable modification. Other examples are waive my requirement to actually take the exam. I'm going to be giving birth during finals. I have A's in all my classes. Can't you just give me an A for the class and I don't have to take the final? If the class requires and our accreditation requires or the passing of the course requires that the student actually take a final, then no, that is not a reasonable modification to waive their requirement of taking the final exam. You may have to put it on pause and arrange for them to take the final as soon as any post-childbirth medical leave is completed, or they come back and take it at the earliest opportunity in the next semester if they can. The next to last note is that students have full discretion to accept or deny any adjustment that is offered to them. So you become aware that the student is pregnant, is nursing or parenting, and may need an accommodation or a modification. You can say, this is what I have available for you. They have full discretion to accept or deny anything that's offered to them. You can't mandate that they take it. You also can offer up some alternatives if appropriate. I can't give you A, but I could give you B, C, and D. Which would you like, if any? The final note on this piece with our adjustments and modifications, what you have not heard me say at all is accommodation, because we're not talking about, in general, under Title IX, we are not talking about giving any pregnant student, nursing student, parenting student an accommodation. That is a very different term with very different obligations for any institution. Pregnancy itself is not a disability. A pregnant student, however, may have pregnancy-related complications that could ultimately require the involvement of your ADA or Section 504 coordinator to assess reasonable accommodations in that situation. That too is definitely a topic for another day and one we can come back to. But if a student is asking for an accommodation that is much more of a change due to a potential disability, direct them to your ADA or Section 504 coordinator. Otherwise, simply because they are pregnant or nursing or a parent, then they are looking for an adjustment or a modification that we can consider providing to ensure they can utilize our education programs or activities, provided that the requested alteration or modification does not fundamentally alter the essential portions of their class, program, sport, club, etc. All right, so as we wrap up, the last little point I want to leave you with and remind you is that Title IX does not require you to ask, guess, or speculate as to whether a student is pregnant or a parent. Your obligations under Title IX kick in once the Title IX coordinator is notified of a particular student's status as pregnant, nursing, or parenting. You do not want to presume anything, but you also do not want to ignore such a student once they have put you on notice. Doing nothing, especially when they need something, is what gets us in trouble. On the flip side, being paternalistic or maternalistic in our approach to that student, especially when they have not asked for any accommodation or modification, can also get us in trouble. So that is a quick guide to the do's and don'ts and a school's obligations under Title IX when we are dealing with a student that is pregnant, dealing with pregnancy-related complications, nursing, or parenting. Hopefully this has answered a few questions for you, and I want to thank you all so much for joining us for this episode today. Of course, if I've left you with any questions, please let me know. Or if you have any suggestions for future episodes, please contact us here at Williams-Mullen. You may also visit our education page at williamsmullen.com. There you will find out more about our team and the types of legal services we provide to the education industry. And finally, please be sure to subscribe to this podcast series to be notified when our next episode posts. Thank you so much for tuning in, and I hope you enjoy the rest of your day. Goodbye.